All right, welcome to lesson number 3, Stand and Deliver. I'm going to start off with probably one of the greatest opening statements in human literature. Two households, both alike in dignity, in fair Verona where we lay our scene. From ancient grudge break to new mutiny, where civil blood makes civil hands unclean. From forth the fatal loins of these two foes, a pair of star-crossed lovers take their life, whose misadventured piteous overthrows doth with their death bury their parents' strife. The fearful of passage of their death-marked love, and the continuance of their parents' rage, which but their child's end not could remove, is now the 2 hours' traffic of our stage, for which, if you with patient ears attend, what here shall miss, our toil shall strive to mend. It's the prologue for Romeo and Juliet. Unfortunately, I don't have it memorized anymore, so I'll work on that for the future reenactments. But today we're talking about the opening statement, the moment where you have to stand and deliver your first words out of your mouth, the real part, right? We do this a little bit in jury selection, as we talked about last week. You've already sort of introduced yourself to the jury, but that's more of a conversation. That's more of an opportunity for you to hear from them. This is the first time the jury gets to hear from you, and it's extremely important. I like the prologue to Romeo and Juliet as a great example of what makes a good opening statement, because it really hits on a lot of the concepts that I will touch upon today. The fact is, if you're going to start speaking, start strong. You need to be able to get a lot of information in a little bit amount of time. You need to hold your listeners' attention, and you need to lay out what really matters, understanding you'll pick the rest up as you go along. As Mr. Shakespeare indicates, that if you pay attention, anything I didn't mention here, you'll find out about as we go along. But you hit the main points. From hearing this introduction, what do we know? Venue, we're in Verona. Definitely that's where the jurisdiction is. We know who the main players are, two star-crossed lovers, and we know what happened. Ultimately, they take their life, and the impact of that is to mend the strife, the feud between these two Italian Hatfields and Coys. So it tells us everything we need to know. So if you get to the end of the play and you're surprised, you just weren't paying attention, were you? So I like that. The other thing I like about it is what I'm talking about today is about the structure of an opening statement. What openings are unique to our practice because it's only about what we think is going to happen. And that means we can go into an opening with a plan. Now, the old adage is everyone's got a plan until they get hit. But at least in that moment, when you stand up to speak to the jury, it's the one time you can probably have a script, right? You have things you know that you're going to get to do. It's also the only time that you get to get up and speak, and the prosecutor doesn't get right back up and refute anything you say. So openings are a very unique experience, but the structure of them can be their strength. And what structure does Shakespeare use? He uses iambic pentameter. And why is that important for what we're talking about today? Right? I can see by your eyes, you're thinking, why is that important, you crazy individual? It's important because once you've created the structure of your opening statement, the structure allows you to do things creatively that you would not do otherwise. It helps control your opening in a way that if you just stood up there and started talking, you would lose control, or at least not be able to do in the same way. And just as Shakespeare using iambic pentameter makes him makes interesting choices and decisions that ultimately elevates the work, utilizing the idea of this structure for your opening statement is going to help you make sure you get what you need, and then make you make creative decisions within that process in terms of what to include, what not to include, because you don't have time to say everything. And just like when I talked about last week that learning and doing things the right way is important, so then you can choose to do them the wrong way or a different way, the ability to have meaningful violation of even these rules that I'm going to give you can be very helpful. Because if you're going to make a decision to do something different than your structure, at least you have a reason for it. And once you know the structure, you know how to violate that structure to your advantage, depending on the case. Because the other aspect, finally, about opening is that it is an adaptive practice still, because we are doing it after we've done limiting, after we've done jury selection, after the prosecutor has made their opening statements. So even within the one place that I think we get to be a little more structured than anywhere else, we still have to be adaptive to what's happened to us. So I want to start out in today's materials. I provided a little outline that I like to utilize about the opening statement, and it gives us this structure that I'm talking about. The great thing as well about having this structure is you can create an opening statement in no time and out of just about nothing. As long as you're hitting these things, you're going to end up with a serviceable opening statement, and with all of your talent, it'll actually probably be pretty good. Primacy and recency. This is why opening statements matter, right? Because juries remember the first thing they hear and the last thing they hear. Everything else is sort of filler in the middle that you're trying to support that last thing they're eventually going to hear. So the decision to do an opening statement typically to me is a no-brainer. I have reserved on them before, which we have the ability to do. It was effective in certain circumstances. I don't recommend it because of that primacy issue. You have to get your story out there as soon as possible, because by the time they've heard the reading of the information, they've had all the discussions in motions in voir dire, and they've heard the state's opening, that jury's ready to go back and convict your client right now. So you have to say something. You know, openings are hard because they're not closings. Closings are great and dramatic and forceful and, you know, the moment where everything comes together. Openings are all framed within what we think may or may not occur. So, but I think they're very important. If you have an opportunity to do one, I think you do one. I think there are very few circumstances where you can reserve, which I'll be happy to talk about, but I always say, almost always, do an opening statement. So when you get up to do your opening statement, the benefit we have in motions and limit, again, voir dire, is the jury already knows who we are. We've already said, I'm Mr. So-and-so, it's my pleasure to be representing Ms. So-and-so in these matters. And they may have heard who you were 2 or 3 times. So you don't really have to do an introduction. So what I like to do though, when you step up, the first words out of your mouth, and you really try and make these no ums, no uhs, no hesitation, just get up there and say one sentence of why you win the case. This is your case theory. Whenever you look at a case, you have a theory of the case. That is what you believe happened, but more specifically, what you believe happened, that means you win. Ladies and gentlemen, yes, an assault occurred on this day, but my client was acting in self-defense and therefore is not guilty of the crime. Ladies and gentlemen, a burglary occurred on this day, but my client wasn't anywhere near the vicinity. Right? Whatever your theory is, your reason you win, one sentence, sum it up, and get it out there, right from the jump. Because this jury is already hearing why you lose. So your primacy, the first thing you should say is why you win. You say it confidently, and you get it in front of the jury. Almost, I think it should be the first thing. When you're using the standard opening that I would do, that'd be the first thing I'd remember. Oh, one reason why I win. Then you can do the introduction. If you feel like, you know, I think it is a good one to kind of get rapport. It allows you a pause moment, though, is what I think of it as. Let it settle. Let your theory settle, and step to the side. Ladies and gentlemen, as I've already said, my name is Jeremy Schmidt. With my co-counsel, Ms. Allison, we're pleased to represent Mr. Jones here today. You know, thank you for being here. Don't go too big into the thank yous or anything like that. Utilize that introduction to start getting to your theory of the case. Wrongfully accused, talking about whether this is a serious offense. Things that start to pique their interest, to start trying to shift the narrative in your direction, whether it's through the burden of proof or just something that starts to move the needle. The next thing we get into in an opening statement is the theme. Now, a theme is different than your theory. I would characterize a theme as the sort of emotional center of your case. It's sort of the creative point that you're drawing from. A man in fear for his life, a man whose back was against the wall, a woman who was in the wrong place at the wrong time. It's this, ideally they're a little catchy, they're memorable, it's a way for the jury to identify with your case in a simple sentence. It's something you get to carry throughout your case. It's something you can always go back to when you go off script to find that center back again. It's something for the jury to relate to. Sometimes they're catchy, sometimes they're alliterative. I think perceptions and misconceptions is one I've used. This is a case about perceptions and misconceptions, right? And there's a lot of variations on these. It's not your theory. Your theory is the reason you win and why. Your theme is where you can find those what I think of as the TV lawyer moments. The moment where if the glove doesn't fit, you must acquit. If it's, a time to kill, if it's few good men, you can't handle the truth type moments. That's where we find those from in our theme. It's the way the jury can attach to our case on an emotional level to understand it more than just as a legal problem to solve, but a compelling emotional reason that they can attach to. And then I would carry that theme throughout your case. I would try and touch on it in some way on all your crosses, on your directs. Because at the end of the day, you want to go up at close and say, we talked about this being a case of misconceptions and misperceptions. Let's talk about some of those and go through it, and then you really pay off. Opening argument is all about paying off throughout the development of the case and finally in closing. That's why it's very important not to overpromise on opening. You want to underpromise and overdeliver, because if you say something's going to happen and it doesn't, juries remember those things. They'll look back at their notes, because that was the first thing they wrote down was your opening, and they're fresh and they're interested and they're paying attention. And as the notes get less and less, they'll be like, hey, they talked about these misconceptions, but I didn't hear about any of those. So you really want to make sure that you're not over-promising. You really, and legally, have to confine your argument to what you believe the evidence will show. Sometimes the easiest way to do that is just frame whatever you want through. The evidence will show this was self-defense. In theory, that's an argumentative statement. You're framing it in a way that makes it real hard to object to. But you got to be aware. It's not the time to argument. It's not time to say the law says this, but they're saying this. It's time to preview. And I like to preview the law. I like to preview the instructions I anticipate if they're appropriate. But it's really just a matter of getting your theory and your theme out there to pay off throughout the rest of the trial. That's why, especially on issues like whether your client's going to testify, is such a difficult one. And even if I'm pretty sure they're going to, I usually reserve on that because it's the juice isn't worth the squeeze. Because if I say you're going to hear from Ms. Jones and then she does not testify, or in the case that I had this happen when I got up and opened and said, and you're going to hear from my client tomorrow, and he's going to get up here and he's going to tell you exactly what happened. And my client decided to take off that night and not return for trial. That put me in a bit of a bind. But it still worked out for us. But it was a real interesting situation. As an aside, Massachusetts has a great missing defendant instruction that we were able to adopt and get our court to utilize, and it's actually very defense favorable. So that's a nice little aside. If you end up with an empty chair next to you, I found that to be very effective. And just tell the other courts that Judge O'Connor did it, so I think they'll be more inclined to go with you. So again, when you're hearing these things, you really want to be making sure you're not over-promising. Only what you can deliver to the best of your knowledge. Things change, jurors understand that to a degree, but if it looks like you came out with self-defense and you ended up with these guys can't prove it, there may be some questions. The next part I talk about after the theme is contradicting the state's theories. It's a very hard balance, an opening and closing, to decide how much are you going to be putting your case forward or trashing the state's case. Sometimes your only defense is just they don't have it, in which case you're going to try and make that the brunt of your argument. That might be your case theory, that might be part of your case theme. But I think when you, and if you're going to contradict, get those contradictions out right away Right after you've got your theory, right after you've got your theme there, right after they know why you win, take a brief moment and tell them why these guys lose, right? If there's things that you can undercut, I would do it soon, so it is part of that primacy, but I wouldn't have it so far forward or so far towards the end that it becomes the focus, because then it sounds like you're chasing their case. And your jurors are thinking, if they're chasing their case, what's wrong with theirs? Why don't they just prove their own? So I would deal with it not immediately, but soon, and then not come back to it until you're on essentially cross-examination, because you want to kind of put the stuff that aren't as strong for you in the middle. So I like getting that out the way. And then you talk about why you win. You get back to that statement. And you can repeat that line. If you got it down to one sentence, every time you're transitioning between points, you can say it again. It's the same thing with themes. Repetition sticks it in people's mind. You have a theme for a reason. You use something alliterative or snappy or Shakespearean for a reason, because it's something that everyone can come back to. But then you go by why you win. At the beginning of this opening statement, I told you that we win because blank. Here's why. First, this witness is going to help us understand that my client was not armed with a weapon when this incident started. Next, we're going to hear from the state's other witness, who's going to help us. There should be something good from just about every witness, even if it's just that we don't disagree with what they say. They're going to help us understand that this happened in Spokane, Washington. Jurors love it when you concede what you can concede, but be sure you only concede what you can, not what you absolutely cannot. So we'll talk a little more about that in closing, because that's much more of a closing concept. But as you'll see in the example I sent out, I'm great with embracing agreement. I truly believe that right out the gate, you want to give the jury something they expect while subverting the expectations as well. And conceptually, juries want to see a trial look like a trial. They want to hear the words objection. They want the counsel pacing back and forth on the stand. We'll talk about movement here in a moment. They want that experience. But then if you can take what they're expecting and subvert it, it's going to give you some more credibility. It's going to make them more attentive to the process. And it could be something as simple as, we agree. They don't expect to hear that. They expect in court that everything's going to be a battle. We're going to argue about everything. And so when you start saying, we're going to agree about most things, there's one thing we can't agree on, and that's what we're going to be talking to you about. Jurors like that. Almost every juror response, and I've had the good fortune to speak to juries afterwards, is they always like it to see when the attorneys are only mean to each other when they have to be. And some trials you have to be, right? And sometimes it's just the way it's going to be with that individual you're up against. But for the most part, they like seeing you be nice to each other, helping each other out, making the prosecutor set up your computer for you, because I can't do anything with computers, and Mr. Deegan's very nice. So, but subvert the expectations a little bit. And just go through those. You just really think of your opening as a roadmap. And when I talk in teaching this class, not this class, but teaching at the law school, we talk about road mapping, where you tell the jury where you're going to go, you let them know when you've got there, and you tell them where they're going next. And I really think that chronological works best. Your story is best when it's told chronologically. What witnesses are going to come up and say is best when you tell them how their order they're going to come in. It just is way easier for people to latch onto. So think chronologically as much as possible, because it's the easiest way, right? And very great, easy exhibits to do are graphs that are chronological, timelines, things along those aspects. Bullet lists. First this happened, then this. Things that really allows it to form as a concrete experience in the juror's mind. Because the one thing you typically don't want is confusion. Because if a juror's confused, they don't make the best decisions. So clarity, and the clearest lawyer is often the lawyer that wins. Because if a jury can understand what you're saying, they can commit to it. So clarity is key. With that, I would suggest, along with that road mapping idea, that is, I told you why we win. We're going to talk about what each witness is going to say. And we're going to talk about what the law is going to be. Then you say, So now we're talking about, this is why we win, because this is a case about self-defense. And when an individual is defending themselves, the court's going to tell you that they cannot be convicted of murder in the first degree. And then you go, let's talk about those witnesses you're going to hear from. First, you're going to hear from Mr. Smith, then Miss Jones, then Miss Allison, and then you talk about what each one's going to say. And you're road mapping, and as you're road mapping, as you're drawing out this path you're going to go down, you're signposting, so the jury knows, oh, we're on the why they win part. Now we're on the who are the witnesses part, and now we're on the conclusion part. It helps jurors track, and the more they can track, the more they're not going to tune out. That's the worst thing. And another important thing about opening is we got to be quick. We saw how Shakespeare did it. He had that all in one little sonnet. We need to be thinking along those lines because limited amount of attention spans. Longer is typically not better. Along with side posting and road mapping, the other concept that I really like and I think is strong, and it plays out the same idea of chronology, is things in threes. A lot of people way smarter than me have studied the impact of doing things in threes. 3 is the perfect number. It seems like a lot, enough to give credibility, and not so much that people get confused. So you'd say, I'm going to talk about 3 things. Why my client is not guilty, where he was that night, or whatever those things are, right? Or you can say, there are 3 reasons we win this case. We're going to talk about all 3 of those, and then you go through them. The biggest thing when you commit to numbers, as we talked about in jury selection aspects, make sure you do. If you're saying we're going to do 3 things, it better be 3. Better not be 2, and it sure as heck better not be 4, right? Unless you're like, oh, I just thought of something else. You can acknowledge that, recognize it, and say there's one other aspect I don't want you to forget about. That may be useful for dramatic effect, but you know, if you're going to say something, make sure it sounds like you meant to say it on purpose. So, things in threes. Everything can work. It's the perfect number for, especially oral advocacy, because it's enough that people can latch onto and can help you create sort of your roadmaps through those problems. That goes along. So ultimately, once you've done that, once you've said why you win, once you've laid out what the witnesses you anticipate they're saying that helps your case, once you've smushed the bad stuff that you have to acknowledge, it's the other thing, right? Where do we put the bad stuff? Directly in the middle. Not towards the front, not towards the back, right where you can address it and move on. Yeah, you're going to hear my client has some convictions for theft charges in the past. You're also going to hear those were 10 years ago. Or you're going to hear that was completely different than this situation. Whatever it is, if it's bad and you really feel the need to address it, it's nice not to be caught off. You never want to give your opposition that aha moment. So the more you can address the bad and then move on, and do it right in the middle. But once you've done those things, it's just about concluding. And you're really getting right back to your, this is why we win. So you get back to that point, your one sentence theory of why you win. You might tie it up into one last little thematic argument, right? Again, ladies and gentlemen, this is a case about a man with his back against the wall. And then the last thing out of your mouth is an ask. That's why at the end of this case, I'll be back up in front of you, giving my closing argument. And at the end of this, once you've seen the facts and the evidence, you will be asked to return the only just verdict, that of not guilty. Always end with what you want them to do. It may seem obvious to us that this whole thing is about this person being found not guilty, but making sure that's at the forefront of the jury's mind, and the last thing they hear you say is not guilty, and you sit down. I think that can be very powerful. And then you have really a structure that you can create an opening from. And the realities of openings is, and as Matt and all of us here, and Jeff, and everybody who's here would talk about, is sometimes you're writing your opening between Limini and their opening. Sometimes you're writing it during their opening, just depending when you get the chance. Opening gives us an opportunity to plan ahead more than we normally do, but if it's a trial where you don't get the opportunity to have your motions and Limini done the week before, when you go directly from voir dire into opening, which can happen, you may be stuck. But you can use this to create a quick roadmap for yourself, and you can get it. Get your intro while you win. get your theme, figure out your what the witnesses are going to say, dispute what the prosecutor is trying to indicate, finish with why you win, and ask them to find your client not guilty. So that is the structure, essentially, of an opening that I think that if you follow, you will be in a good position to be able to work from, to be adjusted. Then you got to adjust. You have to be adaptive. I've included a real-world example. So this is a transcript of an opening that I did. I think I can show some of the things I'm talking. I think it's a decent example of at least the concepts that I'm talking about. I would note that I did delay in the reason why we win aspect, and that was intentional. It was a very difficult jury selection process. People were very hung up on the domestic violence tag, and it created a lot of really emotional responses. And then when they heard it was a burglary, that created a whole nother list of emotional responses. People were very broken up about the concept of a burglary. Now, the entire time we were dealing with the concept of burglary is this person stole my car. They came into my house and took my stereo. So we're really dealing with a lot of what I would say is misconception about what the case ultimately was about, which ultimately created our theme. But I had to address that first before I could even get to our case theorem. And so I have the structure, I just rearranged it. Instead of getting into why the state doesn't win to start with, I led with that, and that helped create our thematic response. Again, this one I used a movie preview, and to me it kind of just made sense because they were getting this preview of what they thought the case was about. This is a burglary and domestic violence, and so they're thinking, violence. They were thinking someone coming in and stealing stuff. What this was a guy that got in an argument with his girlfriend, came back to the house, they continued the argument, and then an alleged assault occurred. He wasn't trespassed from the property, there was no contact orders in place, so they were basing it all on this fact that at some point in their argument she says, "Don't come over here." And so it was a much tamer case than the initial reading of the information and the reactions for jury selection were, but the jury was so spun up by the time we got there, we had to kind of hit that right away. It was also a third strike case, so it wasn't not a big deal either, so it was a lot on the line with it. So, but I liked the movie preview because I thought it was an effective way to, it's like seeing what you think is going to be an action movie and it turns out it's not. Anyone ever see The Bridge to Terabithia? It's this movie, and it looks like it's going to be Chronicles of Narnia, and I'm super pumped because, who doesn't love like Narnia and Harry Potter, stuff like that. Turns out all the fantastical, magical creatures was like some weird dream sequence, and it was more like, My Girl, which is devastating for everybody. So I was hoodwinked.
The book is like that too.
Yeah. But
that movie, Bridge to Terabithia.
Some people that really disappointed me. But it was a good example of something that you expect something, you get something totally else. So I kind of played with that idea. Yes, Jeff?
You mentioned the DV voir dire being really a lot of strung up people.
Yeah.
Did you use individual domestic violence voir dire on that case?
I didn't, and I should have. I think that's...
I have like one time. I didn't on this last case, and I kind of thought people were getting a little bit strung up on it too. And I wonder if we should do it on almost every case. If I go back and forth on that.
This one actually, I think it worked to our advantage because people were so spun up and it made it sound so serious, and that when the facts of this case came out, it really seemed like a letdown. So I think it worked for us in that scenario. I've been doing in my motions in limine somewhat successfully, not letting people say domestic violence, keeping it to family and household member. Do you want to get those actions to find bad jurors for it? Do you want to keep that really prejudicial phrase out? It's a question. It's the same thing with whether individual or not. I think it ultimately worked in this scenario, but I do like the individual voir dire for this because it really does, there is a lot of, this was a very tough jury pool, And we found out later they were even worse than we.
I think mine had the same reaction. They got so spun up,
Yeah.
and then they were kind of disappointed that there's like no assaults or,
Mhm.
and stuff
Right.
like that. But on the other hand, you know, some people have dealt with such traumatic information. It's really hard to do
Yeah.
that in front of the whole group.
Yeah, so I think, and this is why when I talked last week, the trial process is not individual little parts. It's an overarching process where each part goes into the others, which is why I'm very comfortable referencing jury selection during opening, because it gives it a continuity. It creates this entire thing as a living organism that's moving throughout this trial, and it'll help, I think help, because you can find thematic elements in jury selection that you may want to carry over. You're definitely want to try and carry from opening into your examinations and then referencing it back. And I think juries appreciate that too, because then they don't feel like they're just a cog. It feels like a more interactive process. That's why I used a lot of we language, because it makes it seem like, hey, we're all just figuring this out together. And I think that's can be effective. But yeah, so I mean, it carries over, and none of these sections are individual because it's all part of a greater process. So we see that, so I really start with and I address that, you know, I talked about the issues that the juries were having, some jurors were having, as I get into this analogy, and then I preview some of the instructions. And then I get to finally, probably all the way down on page 15 here, but the facts and evidence will show that Mr. Blank went to a home that he was allowed to be at, a place he'd been residing in, and a place that he had a key to. And I get more into sort of the factual aspects of that. But that's what we kept going back to. He was somewhere he was allowed to be. That was our ultimate defense. That whether they had an argument or not wasn't the issue. Even if an assault occurred, that wasn't the issue. The fact was, he was somewhere he was allowed to be. And that's was our reason we won. He was allowed to be here. And in fact, the entire argument wasn't her wanting him to come there, him not wanting to come there, and then it spirals and it's stupid. You know, we can see in here where we address some of the bad stuff. We just talk about that, hey, this isn't good, because we know some of the language and the text messages were awful, really bad, and then they got worse because then he started making some strange racial slurs that were really not applicable to the scenario. But just, I don't know, I don't understand it, but that's what was being done. So, you know, a lot of really negative situations that, you know, we knew that was going to come out. We knew the language was going to be problematic. We knew the 911 call was going to be problematic. So we tried to address that. Why that sounds bad. We could go back kind of to our theme though. It's just like that movie preview. That 911 call wasn't accurate. Yeah, it sounds horrible, but none of that stuff actually happened. So it's just, again, that bad movie preview. You know, we talk about their dynamics and things along those lines. We get into what they should expect. And this was a hard one too, and this is another reality we have to deal with is you don't always know what witnesses are going to testify, particularly in DV cases where it may be up in the air whether they're going with or without their alleged victim. And this was a case where I think the court ruled in a way that I really didn't agree with on the admission of some, not only 911 information, which was probably appropriate, but statements directly to law enforcement as part of the investigation that I think should have been clearly blocked, but they were allowed it all. So they didn't necessarily need the victim to have a case, and so we were debating whether the witness would show up or not. So you don't always know, and that's why here I have to kind of equivocate. We don't know which order they may come in, because once that witness showed up, they were going to put them on, because that was the only chance they got. So it's part of being adaptive and understanding that you have to be ready for everything and keep your opening in a manner that you're allowed to be adaptive. And then finally, you know, we end with, I really like to go back to the law and the facts, but we don't agree, and what we can't agree because it's not supported by the fact. The evidence of the law is that this is a burglary in the first degree. And that's really our theory, right? Whatever this was, it's not legally a burglary. And frankly, this charge could be anything other than a burg one, and the person doesn't go to prison for the rest of their life. So that's why that was what mattered. So I could concede everything else. I can concede there was an assault. I could concede where it occurred, I can concede that some of his behavior was horrific, because your client doesn't have to be perfect, right? And I think when you try and make your client seem perfect, jurors are like, nope, I don't buy that for a second. If he was that great, he wouldn't be sitting in that chair. So the more you can embrace the negative, it's not only, I think, effective in giving yourself credibility, giving your client credibility. I mean, jurors love it when the client gets up there and says, yeah, I've made some mistakes. And you had some theft charges, didn't you? Yeah. Yeah, I mean, 10 years ago, I took a thing of bubble yum and rape. Delicious. And I blamed it on my brother, and then my mom found it, and I had to go back to the store and return it. We may have segued off to another childhood memory, but the more you embrace the negative, the more positive I think you get out of it, and you take the sting out of it, because it sounds horrible when the prosecutor's like, now, Mr. Smith, I have in my hands here judgment and sentence. Have you ever been convicted of theft before? Yeah. Well, sir, what about this? Fresh in recollection, which we'll talk about for impeachment. And that looks bad, but if your client's already said, yeah, no, I had a theft conviction, So, again, just like you do that in your opening, you start to take the sting out of things, right? Things you know that if the juror is going to hear it in a vacuum, they're going to just be shocked. I mean, some of these text messages were just, I was shocked. Shocked to find out that people talk like that, but they do, apparently. So, yes.
So how much will you go into concepts of beyond reasonable doubt and presumption of innocence in your opening?
Very little, because again, that runs the risk of becoming argumentative. What I do, and this is an example where I talk a little bit about what we anticipate the court's instructions are going to be. Because if you're just talking about the law in a vacuum in your opening, you do run against the possibility that it's argument, because you're arguing what the law is or should be. Now, typically, people don't object during openings. I never do. I think it's poor form, and it doesn't make you look good. But it also, when you don't have the instructions in your hand, and you don't know which ones are come in necessarily, I preview it. So, like I do here, and you heard at the very beginning, that's why that opening instruction is so good, because the court's already said that they have the burden. So those ones I think are free game just from a talking point if you want to. You're going to run across some argumentative if you're arguing them applied to this situation too much. I think it's okay to preview it. You don't need to do a huge deep dive into it, but you're going to talk about it. You're going to hear, the judge is going to tell you that the state has to prove every element, and they can't, because the facts and law will not show that this was committed beyond a reasonable doubt. Certainly if your case is more of a, they can't prove it, reasonable doubt, you really want to get it out there more, because when you're not telling your own story, it's just their story is bad. The jury needs to know how to funnel that, and then I would focus on the introductory instructions, because they've already been read, they're already part of the record, they're already part of the process. That's how I would look at it, because the more you get into legal technicalities, you run against that, and you run the risk of overpromising as well, depending on how it plays out. So usually reasonable doubt, you're safe, because you're going to be arguing that same standard no matter what. But I think it's case dependent, but always good to preview a little bit.
Okay.
What do you do when they have a very good story and you've got nothing?
Then that's when you really will figure out where is your, we always have something, there's gotta be something, right? Even if your whole defense is, okay, if they just don't believe this one witness, and then you go back to whatever your theory is, if your theory is, they have, yeah, ladies and gentlemen, you're gonna hear a lot of evidence and witnesses, right? But let's think about what you're not gonna hear about. This is what I usually do when I have nothing. You're not gonna hear about any DNA evidence. I go,
It's not a DNA case.
yeah, you haven't heard anything about, you're not gonna hear, I want you to listen, because the instructions are gonna tell you the evidence or lack of evidence. And when we get back to closing, I'm gonna ask, did you hear about forensics? Did you hear about the crime lab? Ladies and gentlemen, the facts and evidence will show that no DNA was collected.
No fingerprints.
No fingerprints found, no blood spatter. It's a theft of motor vehicle, but still. that's when you really pivot into what they don't have. And that plays with the expectations idea too, because the jurors are expecting that there's this great technical lab where you plug things in and it tells you who did it and what they're wearing when they did it, and it renders a 3D model. And then eventually the two lead detectives fall in love and they open up a cottage and sell Christmas decorations. That was more the holiday Hallmark experience of CSI, but a boy can dream, can't he?
There's a crossover episode.
Yeah, exactly. So you just play, again, subvert that, and as a good aside, because I think that's a good point, it was really in vogue for a little bit for the state to bring up the Prohibit the Csi Effect, which is that defense can't argue about lack of forensic, or that would become the theme of their motions and, their voir dire, that you don't expect. Who here watches CSI? And that's not real, is it? And no one expects that, and we shouldn't expect fingerprints and things like that, should we? No, we shouldn't. I think that's problematic, and I think if you're noticing that it's a trend that you're getting from either a specific prosecutor or office as a whole, I think you can bring a motion in limine to say they can't argue this CSI effect, that doesn't meet the Fry standard. We have no idea if that exists, that's just made up, right? Conceptually, we can, I guess, anecdotally say how we think it would exist, but I've not seen any academic research on it, so something to be aware of, because that may be all we have, is the lack of evidence, the witnesses they did talk to. And you can shift that there. If they've got all these great eyewitnesses, why didn't they talk to the neighbor down the way? Or why wasn't Officer Jones's body cam on? Well, Officer Jones was asleep in his car at the time, but still, let's not get too mired in the weeds on that deal. But yeah, that's kind of what I look to do. When you have nothing, focus on the nothing they have, right? Make it look like they have less, I think is a good.
I was just gonna say, you can even tie that right into voir dire. Like my most recent trial, I was absolutely gonna focus on lack of fingerprints and anything like that. And I just started asking people during voir dire, like, if you're the victim of a residential burglary, how would you expect them to investigate it? What would you want to see done in the investigation?
Because they're gonna try and undercut that, and that is a lot of voir dire too, on cases when you're really with just the patrol deputies. They will really want to make the cutting of corners or the lack of follow-up seem like, it's just what we expect. But it's indicated if you can shift it back as what you want, and then it becomes part of your thing too, because the next standard of that is, well, if we're gonna find someone guilty, shouldn't they do that? They have the burden, right? They have the burden to make sure they proved that Mr. Smith did this beyond a reasonable doubt, and they didn't even go back and try and get surveillance footage. They didn't even look for fingerprints. And you heard from Deputy Jones, he's a good officer. If there had been fingerprints there, he could have found them, but he didn't even look. Things along those lines. And that can play, and that's how you can play through all stages, because there's always a way to win. You just gotta figure out what that is, and then that becomes your theory. You find your theme somewhere in there.
It's those kinds of cases that I have a hard time on. I actually made Zach do an opening on a case where we really had nothing. It was a DNCO.
Yeah.
He got arrested and contacted by the cops very close to the house.
Zach did.
Yeah,
That
yeah,
one.
and I'm here to tell the tale.
And it's
Actually, the jury deliberated for a long time.
And that sometimes is a W, if you can. I had
And I was mad.
No, it makes a difference. I had a case where they had the guy on surveillance with a confession, and something else horrible. And, the jury was out for like 2 hours and 45 minutes. The best part of the whole thing is the prosecutor had to walk around with me because we had to get some scheduling orders signed to move his other 3 cases. And the whole time I was just like, hey, it's been an hour. Hey, it's been an hour 45. That made it all worthwhile. So you find the little victories. But yeah, so you do. There is something. I think you have to approach every case. There is something, even if that something is nothing. Sometimes nothing can be a real cool hand, is the Cool Hand Luke line. So, and sometimes it is. And it's not bluffing. It's just utilizing what is our legal standard. And where are they not raising to that bar to prove beyond a reasonable doubt? And that might be it, How'd they know it was him? They never checked his ID. I mean, they checked his booking photo, and he said it was him. But, let's not get mired in the details. So, definitely. So yeah, that's an example, and then again, just ending with what you want them to do. You want to find your client not guilty. And be very careful. I've heard some very good attorneys get up there and say, and I want you to find my client guilty. And then they sit down and go, God damn it.
Do you hop back up and say,
Either-
just kidding?
Psych. Guilty. Not.
Not.
Not
No,
a joke.
it happens. That's the benefit of scripting opening, though, is that you can, ideally, it's the one area that you could practice if you have the time. You can practice it driving in your car. And that's another thing I would just touch on real quickly. I had to read Shakespeare today, and my undergraduate English professor would have been devastated. But if you can be off script as much as possible, if you can be looking at your juror, and jurors expect you to have notes, they expect you to have things written down, so that's not a problem. The more you can look like you know it, as opposed to you reading from it, makes a huge difference. And every juror, most people's biggest fear is public speaking, right? I mean, that's gonna be a very common one. Your jurors are gonna hate voir dire, and they're gonna understand when you get up there, that you're gonna need to refer to something. But the more you can boil your opening down from a speech to an outline to bullet points, the better you're going to be. And that just comes with time and practice, something we don't get a lot of. So whatever you can do, but the more you can make sure you're looking up, right? Making eye contact, not staring down at people or up at people, but engaging in the process, because it is a connective, right? Your jury's your audience. Your judge isn't necessarily your audience. You may turn to them throughout or that, but the jury is your audience for everything you do. That's the other Shakespearean aspect of this. All the world is a stage. And as a lawyer, all court is a stage. It is performative. That's kind of the final area I want to talk about as we get back to our Shakespearean opening. We return to Fair Verona. Trial is performative. There is an element of that. You don't need to be a Shakespearean actor to do it, but you do have an audience. You have people that have expectations. You have a client that's expecting a performance. And we balance two things with this. The first aspect is the number one thing jurors can smell is bullshit. So if you are creating that for your client or yourself or anything else, juries really are inherently in tune to that. So you have to be you, right? We all can't be the same lawyers as each other, but we all can be great versions of ourselves as a lawyer, right? So that's part of it. You want to be true to yourself. Saturday after school special, whatever. Be true to yourself, right? But the other hand of it is, how do we make it performative enough that we can keep jurors' attention, that we can make our points, that we can hit those expectations and then subvert them. So it's okay to think of it as a little performative, because it is. It's a performance. It's not going to win you any Oscars, but it might get you a few not guilties. So.
You said that there were limited circumstances, but would be some where
Yes.
you reserve.
So a great opportunity to reserve is if there is your two co-defendants. So a multiple defendant case, you both don't need to go necessarily do an opening, especially if your theories are synced up.
Mm-hmm.
You can kind of cover for each other. You obviously have to communicate that, and the hardest thing about co-defendants cases is you're not technically on the same team. And sometimes Steve Reich would have his client testify when you explicitly both agreed your client wasn't going to do but somehow you still manage to, your client gets convicted of crime, trespass, and theft third, but not burglary, so we call it a win, so it was great. But, so you do have to communicate that. So you may choose that one of you will reserve, and now you get a whole nother opportunity before you can put on your case to have an additional opening, as opposed to two back-to-back defense openings, wherever the courts allow it. Again, you're on your own timeline, so one of you can go and one of you can reserve because you have your own specific rights. That's the most effective way I've seen it done, because you don't lose that primacy opportunity. It may be where I've seen it used and haven't done it myself, is I've seen an attorney do it where they just act like the state's case is so bad, they don't even need to. And so by the time they get to their situation, it's like, this is why I waited, you know? I mean, it wasn't anything to respond to. Could be if you really don't know what's coming. You really, for whatever reason, it's possible. You may have talked to all the witnesses, but none of them want to show up, and maybe none of them will. And you don't want to preview anything. I think you're better off in that scenario just saying, my client's not guilty. Or the old, my cousin Vinny. Everything that guy just said was bullshit. It's time to sit down. I think that's better than nothing, and in some ways probably better than a lot of things, but, so those are the limited. If there, it could be practical. You really have to have a good reason though, I think. And I really like it with co-defendants because you're not technically doing it, you're just giving another shot. And then if you really don't want to preview anything, maybe you really want to make that argument right after the state's done. You want to get a chance to get up and tell the jury how bad their case was, like a pre-closing rather. I mean, there's reasons to do it. I just don't find it very often because I truly believe in primacy and recency as very strong concepts for jurors. Other questions? All right, so opening statements, stand and deliver. Feel free to review the materials we sent out just as some examples, and again, transcripts make you sound absolutely insane because there's no real pacing, and the punctuation decisions they make are interesting. But if it's helpful, great. And the other thing to remember is, none of this is perfect. It's all just trying to do the best we can. But if we can create some of these structures for ourselves, it'll make our own job easier and give us the opportunity to break the rules when we think it helps us. So that's what I got. Thank you all for your time.